Hello viewers, welcome to my channel. I'm Hasham. So now I'm continuing the topic of consideration. In the last video, I have explained you about the meaning of the term consideration, definition of consideration and example, and also I have explained you about the essential elements of a valid consideration and what are the different forms of consideration. All these topics I've covered in the last video, and this is the continuation of that consideration part. So in this video, I'm going to explain you about the exception to the general rule, no consideration, no contract. Actually, there is a term, there is a phrase, no consideration, no contract. But there are some exceptions where the contract is there without consideration also. So what are the exceptional cases where without consideration also the contract is enforceable? So what are those? I'm going to explain you. Apart from that, I'm going to solve the practical problems on consideration. In examination, you may get a theory question. Along with that, some case will be given. Now you have to apply your the provisions of the law regarding consideration to solve the case. That's what I'm going to explain you in this video. So before watching this video, I expect you that already you have watched the last video. If you have not watched the last video, go to the playlist of my channel, select the subject business law, select the topic consideration. In that consideration, watch complete video. You can be able to know the meaning, definition, essential elements. Then only you can understand now. Now, here I am going to explain you about exceptions to the general rule, no consideration, no contract. There is a general saying that no consideration, no contract. For on this topic, there is a famous case law, that is Abdul Aziz versus Mazum Ali. In this case, one person, Mazum Ali, has promised to contribute a certain sum of money for the repairs and renewals of the mosque. Later on, Mazum Ali refused to make the payment. He has not paid. The secretary of the mosque has sued him. In the court of law, he says that he has promised to pay so and so money for the repair and renewal of the mosque. Now he's not paying. The court dismissed the case, saying that no consideration is passing. So Mazum Ali is not bound to pay the amount because he is not getting anything in return. So this case law shows that no consideration, no contract. But there are some exceptions to this rule. What are the exceptions? In examination, you may be asked this question. No exception to the general rule, no consideration, no contract. First one, natural love and affection. Suppose on account of natural love and affection between the parties who are in close relationship, even without consideration also, if they enter into a contract, the contract will be valid. But the condition is the contract has been made on account of love and affection, and the parties should be in a near relation, very close relation. Then only, and thirdly, it should be in writing and registered. Example, simple example I'll give you. Suppose a father has agreed to pay a certain sum of money, for example 500 rupees per month to his son, and he has agreed to pay 500 rupees monthly pocket money to his son, and he has written that agreement and registered. Now the contract is valid. Now later on, if the father has not paid the monthly pocket money to the son can sue the father because he has given this in writing and registered. So in case of close relation of the parties on account of love and affection, if they enter into an agreement without consideration, then the contract will be valid. One more case law was there in which an elder brother has promised to pay the debt of the younger brother. He has promised to pay the debts of the younger brother, and he has written this in writing. He has given this promise in writing and registered. Later on, the elder brother has refused to pay because he says no consideration I am getting. The court of law dismissed. He says you are bound to pay the amount because you are agreed to pay the amount in writing, and there is a close relationship between two brothers. On account of love and affection, you have promised to pay the debts of the younger brother. So it's a valid contract. So first case, in case of a contract between close relatives on account of love and affection, if there is a contract without consideration, then also it is enforceable. It is valid contract. Secondly, compensation for past services rendered. A person has given some services to another person without his desire. Without his desire, a person has given some service to another person. Later on, the other person has promised to compensate for that, and he has given in writing. Then it will be a valid contract. Example: Mr. A found the purse of Mr. B. Mr. A found the purse of Mr. B and handed it over to Mr. B. Mr. B says, okay, I will give you a reward of 500 rupees because you have returned back my purse. He has given in writing. Then automatically it will be a valid contract. So even without consideration, also for past services rendered without the desire of the promisor. Without the desire of the promisor, if a person has rendered the past service, it is a valid contract. Next, promise to pay time-barred debt. Suppose a debt has become time-barred and the debtor has promised to pay a time-barred debt and he has given it in writing that I will make the payment. It will be a valid consideration. For example, in India, we have Limitation Act. Limitation Act says a person should recover the amount from the other person within a period of 3 years. If during 3 years, if there is some transaction or there's some part payment, then it will be continued. Suppose if the person has not collected the amount from another person for a period of more than 3 years, the amount will become time-barred debt. Later on, he cannot sue. Example, A has to get 1 lakh rupees from B. A has to get 1 lakh rupees from B, but this amount is due for more than 3 years and A has not taken any steps to recover the amount from Mr. B. So after 3 years, the time-barred debt. Later on, if A puts a case against B in a court of law, the court of law will dismiss the case because it has become time-barred. But if there is a time-barred debt and the other person, the debtor, has given in a written form that I will pay the amount, then in that case it will be an enforceable contract. Next one, completed gift. When gift is given, already gift is given, completed, even without consideration also, it will be a valid contract. Agency. To form an agency contract, it does not require consideration. Without consideration, an agency can be formed. So these are the exceptions to the general rule that no consideration, no contract. So in these cases, without consideration also, the contract will become a valid contract, right? Apart from these cases, other contracts are there. Consideration is must. Without consideration, no contract. That's all. So this is the end of the theoretical part of the chapter consideration, right? Now I'm going to solve some problems. In examination, some case laws will be given, some problems will be given. Now you have to apply the provisions of the Indian Contract Act regarding consideration and solve those cases. So here I have taken some 8 cases. All these practical problems I have given in the link under my description. So go to the description, last line you will find a link, take a printout of these practical problems and then watch this video. Definitely you can get the complete command on these practical problems and in examination you can write the problems. Now first question, first practical problem. An old lady by a deed of gift made over certain property to her daughter D. So an old lady was there, he has gifted some property to her daughter. The name of the daughter is D. Under the direction that she should pay her aunt P, sister of old lady. Sister of old lady is P and D is the daughter. So old lady has gifted some property to her daughter D on the instructions that from this property annually a certain amount should be paid to P. Who is P? aunt, of D, or the sister of the old lady. Now, a certain sum of money annually. The same day, D entered into an agreement with P to pay her the agreed amount. So as soon as she got the gifted property from the old lady, then D entered into a contract with P that every year I will pay so and so amount to P. On that basis, she entered into an agreement. Then later D refused to pay the amount on the plea that no consideration had moved from P to D. Explain the case. So first few years she paid. D paid annually every year some amount to P. Later on she stopped. D stopped making payment to P on the plea that no consideration is passing from D to P. So why I should pay? The case was put before the court of law. The court of law decided no, D must pay the amount to P because consideration is passed not from the promisee but another person. According to Indian law, the consideration may pass from the promisee or may pass from any other person. So here D got the consideration not from P but from the old lady. She got the property, D got the property, daughter got the property from old lady, and that is the consideration. Not necessary that consideration should pass from P. The consideration has passed from the old lady. So the court held that P is entitled to get the allowance from D. That's it. Now second case, two brothers divided their ancestral property equally and agreed to pay 200 rupees per month to mother for maintenance. But after the death of one brother, another brother also discontinued the payment. She filed a case. Will she succeed? Now, what are the contents of the case? Two brothers, they have decided their ancestral property. Agreement they have made is from this ancestral property every month 200 rupees will be paid to the mother. So later on one of the brother died, expired. The other brother also stopped the payment on the condition that no consideration is passing. No consideration is passing. So what had happened? The mother approached the court of law. The court decided that the other brother who is surviving, he has to pay regular amount to mother, because in the case normally what will happen, a stranger cannot sue in the contract. Here the contract was done between the brothers. Now mother is suing one of the brother. Mother is suing one of the son. Two sons have entered into contract, but now mother is suing one of the son. So the law says the stranger to contract that a stranger cannot sue the contract. The rule will not apply for family settlement. This is a family settlement. So that rule that stranger cannot sue in a contract will not apply. The mother can sue the son for getting 200 rupees per month. That is the case. Now third one. Mr. X promised to contribute certain amount for the repairs and renewals of a mosque. Mr. X promised to contribute certain amount for the repair and renewal of a mosque, but he did not pay. Hence, the secretary of the mosque management committee filed a suit. Will the mosque committee recover the amount from Mr. X? The case, the contents of this case are exactly same to Abdul Aziz versus Mazum Ali. In that case also, Mazum Ali has promised to pay a certain sum of money for the repair and renewal of the mosque. Later on, he refused to pay. Then the management committee of the mosque approached the court of law that this person has promised to pay so and so money for repair and renewal. Now he is refusing to pay. The court dismissed the case, saying that no consideration is passing from the mosque to the person, Mazum Ali. So here the case says no consideration, no contract. So Mr. X is not bound to pay the amount to the mosque because no consideration is passed. So the court dismissed the case. The court says the mosque committee cannot recover the amount from Mr. X. Next one, Dharam. Dharam, out of his free will, offers to sell to Karam his watch worth rupees 500 for rupees 50 only. Dharam, a person, out of free will, he agreed to sell his watch. Actually, the value of the watch is 500 rupees, but he has agreed to sell the watch for 50 rupees to Karam. Karam accepts the offer. On Dharam's refusal to perform the promise, Karam files a suit against him for breach of contract. Later on, first of all, Dharam says to Karam, will you purchase my watch for rupees 50? Actually, the value of the watch is 500. But he says only 50. Karam says, okay, I will purchase the watch. But later on, Dharam says, no, I will not sell you the watch. Now, Karam has approached the court of law. Now, Dharam pleads inadequacy of consideration. Will Dharam succeed? Now, Dharam is saying the consideration is not adequate. Inadequacy of the consideration, because the value of the watch is 500 and he wants to purchase it for 50 rupees. Inadequate consideration, so I will not sell. The court dismissed. Court says Dharam must sell the watch at 50 rupees to Karam, because the law will not see the adequacy. The adequacy should be settled by the parties themselves when they enter into contract. So the court will not interfere into the adequacy. So Dharam is bound to sell the watch at rupees 50 to Karam. Next, fifth point. Abhishek, the only son of Amitabh, fell into a river and Vivek saved him. So Abhishek is the son of Amitabh and he fell into the river and Vivek saved him. Amitabh in gratitude made an oral promise to pay Vivek 5,000. But Amitabh died before making any payment. Vivek claims rupees 5,000 from Abhishek. Will Vivek succeed? Give reasons. Yes, Vivek will succeed in getting the amount from Abhishek, because the promise, the Amitabh has made the promise for past services rendered. Just now we have seen one of the exceptions. One of the exception is compensation received for past services rendered. So here Vivek has rendered the services in the past for which Amitabh has promised to pay 5,000 rupees to Vivek. Later on, Amitabh died. Now the legal representative of Amitabh, Abhishek, must complete the contract. He has to pay 5,000 rupees to Vivek. Now sixth problem. Ram and Sham, two Hindu brothers, divided the family property between them and agreed at the time of partition that they should contribute a sum of rupees 50,000 in equal shares and invest it in the security of immovable property and pay the interest towards the maintenance to their mother. Can the mother compel her sons to have the amount invested as settled in her favor? So Ram and Sham are two brothers. They have agreed that they will sell away the ancestral property and make investment in some securities. And every year they will get interest on those securities. The interest will be paid to the mother. That is the agreement made. That is the agreement made between Ram and Sham. Later on, they have not made the investment. They have not paid the interest to mother. The mother sued the sons. The court says even the mother is stranger to the contract, because the contract was made between Ram and Sham. So mother is the stranger, but still mother has the right to sue the sons Ram and Sham because it's a family settlement. So in case of family settlement, that rule, stranger cannot sue the contract, will not apply. The mother can also apply. Next, seventh question. B spent some money on the improvement of a market. B spent some money on the improvement of a market at the desire of the collector of the district. The collector of the district asked Mr. B to make the improvement of the market. So B has spent some money on the improvement of the market. Then in consideration of this, D, who was using the market, promised to pay some money to B. D is another person who is using the market. D promised that I will make some payment to B. Now, can B recover the amount from D? The question is, can B recover the amount from D? First of all, B is spending the money on the improvement of the market at the desire of the collector. At the desire of the collector, B is spending the money and making the improvement. Later on, another person, D, is there. He promises, D is the user of the market, and D promises to B that I will pay you some amount. I will pay you some amount afterwards. Later on, D has not paid any amount to B. Can B recover the amount from D? No. B cannot recover the amount from D because the consideration should move at the desire of the promiser. The consideration must move from the desire of the promiser. Here the promiser is collector. The promiser is collector. Collector has directed Mr. B to make the improvement in the market. So consideration is not moving from B. So the court has dismissed the claim of B. B cannot claim any amount from D. Next one, last and final question, 8th point. A agrees to transfer certain properties to be held by T in trust for the benefit of B. Can B enforce the agreement? Yes, of course. So A agrees to transfer certain properties to be held by a trust. T is the trust. So A has given some properties in the name of trust for the benefit of Mr. B. The trust was formed to give the benefit to B. Later on, B was not getting the benefit. B has sued the trust. Saying that you are not paying the money. Trust says there is no contract between beneficiary and trust. But the court dismissed. Court says the consideration already passed from A. So B is eligible to take action against the trust. That's it. So 8 problems I have selected on the point consideration. These 8 points I have explained each and every point. Watch the video twice, thrice, definitely you can be able to get the points of these practical problems. But before that, you must have a printout of the problems which are given in the link. So these 2 videos I have completed the topic consideration. I have explained you the meaning, definition, essential elements of consideration, and then lastly, exceptions to the general rule, no consideration, no contract, and practical problems are solved. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. Give your comments on these videos. And lastly, don't forget to subscribe my channel if you have not yet subscribed. Inshallah, I'll continue the next topic in the next video.